I want to move on now to the family law inquiry that Prime Minister Scott Morrison announced last month. There's a bit of controversy about this, which we'll get into in just a moment. First up, let's have a look at what Scott Morrison said around about the time that he announced this inquiry, which is going to be co-chaired or deputy-chaired by Pauline Hanson.
Will the Prime Minister inform the House about the establishment of a wide-ranging inquiry into the family law system and the importance that the inquiry hears from all sides of this difficult and complex debate?
This is an inquiry that is in addition to, not in place of, the significant work that has been undertaken. And by point of reference, I refer to the Henderson inquiry, which, through that focus on the domestic violence, just this week, as a result of that inquiry, it is now unlawful for a victim to be cross-examined, Mr Speaker, by their abuser, and that is just one of the many responses that our government will be introducing.
Prime Minister Scott Morrison there, dealing with some of the opposition already to this inquiry. I would have thought most Australians realise that there's many issues to look at in the family court system, but there has been a lot of criticism for Pauline Hanson, saying that women are making up claims, are inventing claims of domestic violence abuse in order to win sole custody of their children. I'm joined on set now by child psychologist Clare Rowe, who works in this system day in, day out. Thanks for joining us again, Clare.
No problem.
Tell us about, in the broad terms here, you deal in the family law court system day in, day out, as I said. Do you believe there's enough problems in the system? We know about backlogs, we know about all sorts of controversy. Do you think it warrants a full inquiry?
I think it warrants a full inquiry if that's going to translate into some changes in action. And I think I welcome that if that's the case. But we're then looking at probably another couple of years before that can happen. And what happens to this backlogged, just protracted, awful, toxic system that kids are growing up in at the moment. So, as we heard, the Law Reform Commission's already handed down 60 recommendations, and many of those I think are pretty sensible, and they're aimed at kind of reducing time delays and so forth. So I would really encourage the government in the meantime to respond to those. And can we not have those happening together if there must be another inquiry? And we've got to remember the family law courts have been the subject of more inquiries than any other court in the land. So it has to have some action to back it up.
Yeah, so inquire, yeah, maybe, but there's already a lot of reform that needs to be put in place. Changes need to be put in place now.
Yeah, I mean, anyone who works in the system like myself, whether you're a psychologist, whether you're a solicitor, judge, we can already tell you what the problems are. I think that's
what are they,
widely
primarily? What are the key problems?
Primarily it's time, and that would come from under-resourcing. These families are waiting years upon years for final court dates. So kids are literally growing up in the system. And I think when you get a system where families are so acrimonious and litigious and toxic, the family court stands to be kind of a non-adversarial court. But as you can imagine, it's probably the most adversarial court. People are literally, as they believe it, in the fight of their lives in there.
So isn't the biggest reform we need in this area to prevent people going to the family court? Don't we need to... So it's not really a reform of the court system, but really a reform of the broader community services system, I don't know, education, whatever else we can do to try and encourage people where there's a marriage breakdown or a relationship breakdown to deal with it as much as possible themselves before they get into this court situation.
Yeah, and I think those things are in place. Couples have to mediate before, obviously, they can put an application into the court. I think, again, it's time. It's catching them really early and having some intervention in the months where there's some toxicity and conflict brewing. Even to get mediation appointments and to go through family therapy and things like that take months. I mean, I've heard of families of, we'll come back to us in 6 months, we'll have an appointment for you. So by then, the hostility's growing, the anger's growing. We go and seek some advice from some lawyers and suddenly it's all on.
Now, it would not be a surprise to any adult in this country because we're all touched by this issue, at least indirectly, through friends and family. Surely it would surprise no one that in the cases where there are custody battles, that untruths get spoken by mothers and fathers.
Absolutely. So you've got to understand the family court, unlike other courts, doesn't rely a lot of the time on objective evidence. So often there is no objective evidence. So what they're relying on is submissions to court as evidence in the form of affidavits, which is he said, she said. And that's what the court's presented with. And as I said, we're in a highly emotional state where people are desperate. And when you're in a state of desperation, anyone who works in the family court, will say that people lie. And that's not new to us working in the family court. And they lie about anything. Now, whether that's domestic violence claims, whether that's physical abuse against children, whether that's sexual abuse against children, people lie. They become desperate. It happens.
So when Pauline Hanson says there is a problem with women lying about domestic violence against men in order to get sole custody of children, forget about a myriad of other issues we could talk about, but when she says that, she's speaking the truth.
Yeah, we need to come down to facts and have a very kind of middle ground discussion here. And I think that kind of emotional, inflammatory statements on both sides aren't helpful. Now, when you come down to it, it happens. It happens. I see it weekly. I see it in my rooms. Now, that's anecdotal clinical evidence on my part, but it happens, absolutely.
You see fathers who are denied access because of lies told against them?
Yes, and mothers. I see parents in general denied access for months or years at a time. By the time we work out whether these claims are substantiated or they're dismissed, often a parent has not seen that child for a very long time.
So that's a good starting point in this debate, because there have been so many people out there trying to shout down Pauline Hanson saying she's wrong, but you're saying that she is obviously correct in a factual sense, that what her observation is true and therefore warrants investigation.
Yeah, I don't see any part, and I've tried to look up, anything that Senator Hanson said, and I don't see any part that she said the majority of women make up these claims. I don't think she said that it doesn't happen, that men make up claims, and I don't think she said that she was kind of anti any support or conversation we have around the victims of domestic violence. It is one very narrow issue that she has called out, and on a factual basis it's true. Now, people who have shot down Senator Hanson have said, oh, that's the minority of cases. But when we're talking about thousands of families going through this family court system nationally, that's a lot of children. If we're talking kind of 10% even under of cases that are denied access to a parent based on a falsehood, we're letting down those children. We're denying them that right of having a parent.
Yeah, no, it's good to hear you say that, and I quoted you in my Australian column on this today, because it's simply wrong to say that Pauline Hanson's wrong on this. Now, as you intimate, there are all sorts of other issues, right? I mean, so of course, if there are women lying about men, there are men lying about women, and some studies have shown that more men tell lies about women than vice versa. Other studies show broadly that about 10% of claims going to the family court could be false. And as you also intimate, it might not be the biggest problem in the whole system, but it's certainly one aspect that any inquiry will need to look at. How do you actually drill down and test claims when the ramifications of those claims can be so severe, not just for the two parents, of course, but for the children?
Absolutely. I mean, they're lifelong ramifications for children who are denied access to one parent because of this falsehood. And I've certainly had children anyone who works in family law knows the effect that false memories can have on children, of brainwashing of children, etc., etc. Yes, it is a minority of cases, but I'm not prepared as a child psychologist to turn my back on what is a minority, i.e. in that pool of people, hundreds of kids. And we've got to remember, in hundreds of cases, they're not necessarily one child in each family. We're talking about multiple children in each family. I'm not prepared to turn my back on them and say, I'm sorry, you're the minority, and look, the majority are legitimate claims, so we've got to ignore that. At the same time, we've got to be prepared to have the discussion. It is one particular issue in the family court. It is not the major issue, and as far as I can tell, Senator Hanson never said it was the major issue. But if we're not prepared to come to the table and say, this is an issue, what do we do about it, we're absolutely failing a huge number of kids there.
On that particular issue, and just say it's not the major issue for the inquiry, but on that issue of false claims, where there are no police complaints or files, where there's no substantive evidence, are children the best arbiters beyond a certain age, or as a child psychologist, does putting children in that position put too much pressure on them?
puts a huge amount of pressure on them, absolutely. The notion of a child's best interests and also a child's wishes is one that's highly contentious within the family law field professionally. You know, what age should we listen to a child? You know, I don't want to go and see my dad at 5 years old and we say, well, you don't have a choice. You know, at 13 years old, do we give them that choice? To date, there's no current age that we say, right, when you are this age, you can decide. And that's often a falsehood between parents. I mean, they think once my child reached 12, 14, they can decide. And that's not true. A child's wishes and a child's, I suppose, witness testimony of what has been going on is only one part of what has to be a highly comprehensive but highly skilled area to assess these families. And at the end of the day, that assessment needs to happen quickly. We need to get in, we need to assess these families, work out what's going on to the best we can, and then make recommendations going forward. But dragging it on for years isn't helping anyone.
Yeah, traumatic area. And in summary then, you said that's not the biggest issue. The false claims is not the biggest issue. The biggest issue you would say would be dealing with cases more quickly, and that would presumably, among other things, require more resources.
It does come down to resources. One of the other issues that I know Senator Hanson talked about that it has received also some more backlash is the fact that, you know, this is perjury if people are lying in court and they're not charged with perjury. In its attempts to be a non-adversarial court, the family court is very reluctant to have consequences for people who do give false claims. And perhaps we need to start looking at that as well.
Yeah, fair point. It's one that Pauline Hanson actually made along the way too. Thanks so much for joining us, Claire.
No problem.
Appreciate it.